The Constitution of India is a major electoral issue in the ongoing Lok Sabha polls. Opposition leaders have levelled allegations that the BJP will alter or even destroy the Constitution if Prime Minister Narendra Modi secures a third term. The BJP has vehemently dismissed these claims and in fact suggested that it is the Congress and its alliance partners in the India bloc who intend to amend the Constitution. The Constitution of India stands as one of the world's most esteemed legal documents. It delineates powers of the Legislature, the Executive and the Judiciary, and it lays guidelines for center-state relations. It also enshrines fundamental rights for the Indian citizens. Despite its amendable nature, legal experts assert that altering the Constitution is extremely challenging.
Doctrine of basic structure says that the basic object of the Constitution, what existed at the time of implementing it, cannot be changed. And that was the Keshwanand Bharati judgment also says, that the basic structure of the Constitution cannot be changed. But other changes, if the Parliament thinks fit and if there is a majority which is required as per the Constitution, that can be changed. But only radar is that it should not be the basic structure.
The Constitution's amendable nature is regulated by Article 368, which outlines the amendment process. There are three kinds of amendments. Amendments that can be undertaken by a simple majority of the Parliament, amendments that require an absolute majority, that is, more than 50% of the total membership of each house, plus a special majority, that is, a majority of the total membership of each house, and a 2/3 majority of members present and voting. Amendments that not only require the above-mentioned special majority, but also need ratification by at least half of the states in India. Matters such as changes to the Constitution, removing a sitting president from office, and creating new states come under the third type that require strong agreement among members of Parliament as well as a ratification by at least half of the states in India.
The Supreme Court in 1973 had said that you cannot change the basic structure of the Constitution. So even if you get 545 MPs in Lok Sabha and 250 MPs in Rajya Sabha, through a constitutional amendment, you won't be able to change the basic structure of the Constitution. Now, this judgment is coming after Golaknath, where Supreme Court has said in 1967 that Parliament cannot amend the Constitution. To amend the Constitution, it has to create the Constituent Assembly. And the argument of Supreme Court in that case was, since Parliament is the creation of the Constitution, it cannot destroy the creator. A happy wedding of two extremes, that you can amend any provision of the Constitution at will and that you cannot amend the Constitution at all, was reached in 1973 when a 13-judge bench of the Supreme Court said that Parliament can amend any provision of the Constitution, but it cannot destroy the basic structure of the Constitution.
The basic structure of the Constitution comprises democracy, federalism, separation of powers, judicial review, and secularism. Experts assert that the Parliament cannot amend these fundamental tenets of the Constitution.
Firstly, for the change of Constitution, you require 2/3 majority in both houses of Parliament. And Rajya Sabha doesn't change overnight. Rajya Sabha has a process of change, and any party or any group of parties to get 2/3 majority in Rajya Sabha cannot happen with this election. So really speaking, it is completely unrelated.
Hence, while the Indian Constitution can be amended, its core remains safeguarded according to the constitutional experts. The judiciary retains the authority to review amendments, thus ensuring adherence to the Constitution's basic principles.